Hello. Well, now that the Presidential Election Petition Tribunal has delivered judgment in the petitions filed against the victory of President Bola Ahmed Tinubu, I just thought to make one or two observations. On the issue of double nomination canvassed by the APM, Allied People's Movement, I think that the decision could have gone better than what we had yesterday, with the greatest respect to the law lords. The court declared that double nomination of a party or a person to an election does not form the basis in law for which that person may be disqualified from that office. The court, in our wisdom, has said that since the Constitution has made mention of the requirements to be president or vice president of Nigeria, nobody can add to or remove to it. I think that the court should have just gone ahead to say that the provision of the Electoral Act prohibiting double nomination by parties or persons to an election is of no effect, null and void. Maybe the court should have also gone ahead to say that any other provision in the Electoral Act or any other enactment that reduces the ability of a person to contest an election that is not expressly contained in the Constitution is also of no effect. Again, the court mentioned that even if they were to have considered that reasoning by APM, the APM ought to have shown that Shetima knowingly allowed himself to be nominated in two elections in the same election cycle. I think that this would have been a little too far, since it is now sounding more like a criminal matter than a civil matter. Recall that civil proceedings are conducted, won and lost, based on the preponderance of evidence. That is, how heavy your evidence is, and if that evidence is not rebutted by the other party. It is not a matter of beyond reasonable doubt, which happens in criminal trials. So I think that the deploration of the word mens rea and its attributes, in this case by the court, does not or ought not to have a reason. Again, even if we were to look at the evidence before the court, I think that the indication that Shetima had accepted nomination as senatorial candidate and also accepted nomination as vice presidential candidate is sufficient to show that he knew what he was doing at the time. I would have thought that the court would have found its way to state the irrelevance of that admission and not to put the burden on the APM to show how he knew what he was doing. Lastly, on this, I think that the court should have utilized the opportunity to tell us when a person or a party is clearly withdrawn from contesting an election. The APM made the case that it is not when notice is given to the Independent National Electoral Commission, but when a person has deposed on affidavit of withdrawal, that is the effective time that the person has withdrawn. Remember that an affidavit is a document made under oath stating that all the facts contained therein are true. The effect of this declaration is that if any part of the affidavit is found to be untrue, the person making those declarations is liable for the offense of perjury. Therefore, it means that at the time of making the declarations, the facts contained in are true. Since Kabiru said that as at that day he had withdrawn from being the vice presidential candidate of Bola Ahmed Tinubu and the APC, the APM is saying that that is the date the court should have reckoned with and not even when notice was given. The essence of this argument is to show that Bola Ahmed Tinubu, for a continuing period of 14 days and more, did not have a vice presidential candidate. As a matter of fact, 21 days as against what the law requires, 14 days maximum. If the court had directed itself towards this argument, I think that we may have had a better resolution of that issue. We'll still wait to see what the parties will canvass at the Supreme Court if they do go to the Supreme Court. It's been Ayede School of Law. Thank you.